Now, on Law and Crime Report, Ben Crump and the family of Breonna Taylor are saying Kentucky DA Daniel Cameron failed to appoint a special prosecutor and therefore should recuse himself from the case. Plus, the St. Louis couple who were seen waving their guns at protesters are now facing an indictment from a grand jury. And later, prosecutors and investigators uncover racist social media posts and texts in the case against Ahmaud Arbery's killers. This is the Law and Crime Report, diving into true crime and all legal stories making headlines. Good afternoon, I'm your host, Brian Buckmeyer, here at the Law and Crime Report. We've got a number of great cases lined up for you, so let's jump right in with the first one. The first is the case of Breonna Taylor. Now, last week, the audio recordings of the grand jury testimony was released, and many of us are going through it, still scratching our head and asking many questions as to how this ended up the way that it did. Now, Benjamin Crump, the attorney for the family, has released an open letter saying that Daniel Cameron, the Attorney General of Kentucky, should recuse himself and stand down while this case continues going forward. Let's take a listen.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian.
All right, so I'm joined with our two guests, Eklund Mercy as well as Gene Rossi. And I did have an opportunity to actually listen to these audio recordings. And before I start with Eklund, I want to just flush out what the Attorney General has said there. In the recordings, only the officers say that they heard a knock and announce. Every other witness said they did not hear either. The witness that he's referring to spoke to the Attorney General's office twice over the phone. On the first time, he said he heard neither a knock nor an announce. On the second time, he said he did not hear the knock, but heard the announcing. But the Attorney General agreed that he had a language barrier that they did not know of, and so that's all they have to know. So in terms of saying that someone clearly said there was a knock and announce, it's someone who had a language barrier and flip-flop on their answer. Eklund, armed with that information, and that was given to the grand jury, what are some of your reactions to this indictment or lack thereof in the case of Breonna Taylor?
I am shocked. Like, since when does a prosecutor during grand jury provide defense tactics? I've never seen that. And at the moment in which evidence is contradicted, that's a fact question. That's supposed to go to the jury. You're not supposed to answer it. That's the prosecutor trying to be defense counsel as well as prosecution. You don't do that. You can't be the judge, jury, and the executioner. He wasn't. He was out of his wheelhouse. At the moment in which the evidence contradicted itself, at the moment in which we have one witness saying one thing, another 11 witnesses saying something else, that's a jury question, and that's something that should have been presented to the grand jury. And so it should have been presented at trial. And my issue is that he came in trying to be a defense attorney to the police officers, and we have a problem. That's the problem. And the biggest thing is the fact that he lied to reporters. He stated that he presented all the homicide charges. That is what he said. That is what he said to the public. And the grand juror, like, to have a grand juror so moved, so passionate that he did not do what he said he was doing, to even hire an attorney because he lied, is a problem. He should stand down. He should recuse himself. This was a gross misuse of justice. At the end of the day, even if the officers were found not guilty at trial, they needed their day in court. Breonna Taylor needed her day in court, and she wasn't granted that, and that's the problem.
Yeah, and Gene Rossi, I tend to agree with Eklund. And for me, this was more of a procedural issue. This was something that I think that should have been able to cross the threshold of the grand jury and should have gone to a trial to flush out some of the inconsistencies and to see, and as Eklund is saying, to have their day in trial. As I told my wife, with prosecutors like this, I don't think defense attorneys need to exist because he was kind of playing defense in the grand jury, and I don't have that in my cases. I've got to fight for these things. What are your thoughts, Gene Rossi?
I have a couple of thoughts. Number one, he is way over his head. I don't think he's ever tried a case. I don't think he's ever done a grand jury. He's an elected attorney general who was a protege of Mitch McConnell. So that's a problem right there. Problem number two, he was holding a press conference like a politician. And when you're an attorney general of the United States or of a state, you shouldn't be a politician. You should present the facts as they are. Third comment is, and I respectfully disagree with Eklund. The problem with this grand jury is they were pure defense attorneys, the prosecutors. They only provided one side of the equation. I had many hours in front of the grand jury in my 27 years as a federal prosecutor. What I would do is this. When I went into that grand jury with an indictment, I want an indictment returned by probable cause, which is that much. It's nothing. But I would often put in some of the defenses of the defense just to be fair. Like I'd say, listen, so-and-so said A, B, and C, but they're cooperating, trying to get a cut in their sentence. So I would kind of put in a little bit that would help the defense, even though I did not have to. But in this case, they were pure, unadulterated, categorical defense attorneys. That's a shame.
Yeah, Attorney General, like I said, Daniel Cameron is going to work me out of a job by presenting cases like this to the grand jury. Now, the family of Benjamin Crump is openly saying they disagree with the process, and they're asking for it to be changed in a press conference. Let's take a listen.
Well, if he didn't present these things to the grand jury, what kind of sham grand jury proceeding was this?
Yeah. Yeah. Dog and pony show. Yeah. Sham. Kangaroo court.
Had enough time. It follows a pattern. It follows a pattern, Bianca, of the blatant disrespect and marginalization of black people, but especially black women in America who have been killed by police. Because part of Breonna's legacy will always be, just like Trayvon Martin and Michael Brown raised America's consciousness level and attention to Black Lives Matter, Breonna's legacy will be that black women life matters too.
Now, Gene Rossi, I have to say, as my mother's child, I have to be fair and even, as she taught me to. When we listen to these grand jury proceedings, we don't have, I think, the most important part, and that is what the Attorney General's office presented as charges to the grand jury. So right now, I think, for the most part, and I'll admit myself, I'm speculating as to how this information could have been converted to the indictment or the lack thereof, because I don't have that pivotal piece as to what charges were presented. Gene, how important is it to have that aspect of the grand jury to really know if something went right or wrong?
Well, here's the thing. When you present testimony, witness testimony before the grand jury, and after those witnesses are done, you have that fork in the road, the moment in truth, when the prosecutor says to the grand jury, I have a copy of the proposed indictment. We've heard the evidence. I leave it with you. And if they vote yes, the grand jury has done their job. If they vote no, they've done their job too. But there has to be transparency and there has to be a fairness of application. What I gather from the grand jury presentation, it was incomplete. It wasn't presenting both sides of the equation, and it was tilted toward protecting the defendants, the alleged potential defendants, and it had relatively little concern for Breonna Taylor. That troubles me greatly.
Yeah, and Eklund, about the lack of Breonna Taylor being present in the indictment, When I looked at the indictment as well as the information that was presented, it was almost as if Breonna Taylor was an afterthought. It was like she wasn't really present there. Even the reference to Breonna Taylor, she was always referred to the body laying there. Her body, her body. There was very little information. If you had gone through this quickly and you didn't read the news and you didn't hear about Breonna Taylor for all the avenues that we've been hearing about her, if I only listened to this grand jury presentation, I would never have known that Breonna Taylor was there. It just seems so empty. What were your thoughts on that, Eklund?
You know, as a Black woman, it hurt. It hurts, and it hurts often, because when you look at the grand jury, when you look at the indictment, when you look at AG Cameron, it's like Breonna Taylor was an obstacle. She was a casualty of war, collateral damage per se. The real damage was to the wall, but Breonna Taylor was collateral damage. They don't understand at some point you have to read the room. At some point you have to see what's greater, what the issues are here. We don't know the intent of those officers. When we will know the intent of those officers? When those officers are on trial. And for AG Cameron to present a case like just devoid of any compassion to the victim, I've never seen that happen before in a prosecutor's presentation of a case. I've never seen them not really refer to the victim. Matter of fact, I've had to make motions that so they don't refer to the victim as victim. They say Miss so-and-so and their poor lifeless body when they're presenting a case. And we had none of this here. We had none of it here. It was like she was an afterthought, and it angers me because it keeps happening. And at what point it's like, yes, do Black lives actually matter? Because it didn't matter in this case. And that's the recurring theme here. Do we matter? And it doesn't seem like we do.
Exactly. I'm going to leave it there, Eklund. I'm not even going to add any words to that because how powerful that was. We're going to take a quick break and come back with more here at the Law and Crime Report. All right, welcome back. A case is getting attention after almost a decade. That's the case of Oscar Grant. Some may know Oscar Grant's story from the movie Fruitvale Station, played by Michael B. Jordan, of a young man who was shot and killed unarmed at the Bay Area Rapid Transit area by an officer in the subway station on New Year's Eve. Now, one officer was already tried and found guilty of involuntary manslaughter in 2010, where he was sentenced to less than a year in jail. That's Johannes Messerly. However, another officer seems to have some similarities to what happened to George Floyd, and the family making a call for more transparency and for greater charges. Their calls have been answered by the Alameda County DA, Nancy O'Malley, who's looking to reopen that case. Again, I'm joined with Eklund Mercy and Gene Rossi, so let's jump right into this. Eklund, during the break we were talking about this. I know you didn't watch the movie, but you know about the case. It's a tragic case that we've heard about, and really, it's a story that's been going on and on and on again, but it seems that the political wave and this push to having justice in the means of prosecuting officers who commit certain acts, that seems to have caught up in this case. What are your thoughts about reopening this case and potentially going after this officer who was in charge, Anthony Perrone?
Well, I need to know the intent behind it. Now, if it's merely for transparency to see that not only these officers were they indicted with the correct charges, but the supervisors, the superiors who hid evidence, who tried to protect them. If that's what you're looking for, then I'm all for it. But if it's for the purposes of muddying the waters 30 days before, an election to try to get sympathy for these officers, then it's a problem. So it's a thin line, because with everything that's happening, to open this wound and if you open this wound and you don't have a clear plan of what you want to happen, is a problem. So I'm kind of skeptical on whether it should be opened or not, because if you don't have a clear plan, if there's not like a point of attack, then you're just blowing smoke and you're just making people angry and just confused at this point.
Exactly. Now, Gene Rossi, let me play a little devil's advocate here. This is a case where one officer was tried and convicted for involuntary manslaughter. There is a sliver, at the very least, of justice that was found there. Now, another officer didn't go through the same route. Talk to us about the wisdom and maybe the precedents that could be formed here of reopening a case like this and prosecuting potentially a second officer for this manslaughter.
All right, here's my views on people who are shot and killed. That's number one. And if an officer may have done it. Regardless of how a person is killed, whether it's a lay person, an officer, anybody who contributes to that death, you always investigate and prosecute if the evidence is there. That's number one. But when you have an officer who may have aided and abetted, and if Mr. Perone aided and abetted or contributed somehow to this death, I don't care if it's 15, 20 years ago, I am going to go after them if I have the evidence.
Yeah.
All right, so let's see how this goes. This is just about the reopening of the case. We've got to follow the evidence. That's what we do here at Law and Crime Trial Network, and we'll see where this leads us. Let's switch gears now to another story that we've been talking about in the past, and that's the McCloskeys. This is a St. Louis family who was seen on video brandishing weapons at protesters. Now, they're saying that these protesters were trespassing on their property, and so therefore they have the legal right to display weapons in this manner. Now, Gene Rossi, I'm looking at some of the indictments, and initially the grand jury came in just being presented or the information of exhibiting weapons. Now, that is a Class D felony punishable by up to 7 years in jail, and the statute is basically saying presenting or exhibiting weapons in an angry or dangerous manner is a crime. Now, self-defense can apply there, so they can get off on that. But the grand jury also added tampering of evidence, which, based on the fact that that tampering has to do with a felony, is also a felony charge. Talk to us about this indictment. Talk to us about the potential of this prosecution and how they're arguing self-defense may apply.
Okay, for the first charge of brandishing, the couple has a self-defense argument. There were allegedly protesters outside that were threatening them, yelling at them. This is what they may say. And they were fearful. The gate was pushed, allegedly. So they held those guns to defend themselves and their property. You can defend yourself. Your property's another matter. But they may have a self-defense case. But the tampering issue, that one is going to hurt them at trial because jurors understand self-defense. They don't like tampering. And what tampering shows is consciousness of guilt, and it's a relatively easy charge to prove.
All right, so let's listen to what the defendants believe their self-defense claim stands from, and that is defending their property.
All right, y'all see he got a gun and shit, and y'all can see. Y'all see on my live feed, he got his rifle. Y'all can see. He does have a weapon. As y'all can see. This individual does have a rifle. Y'all screenshot this. Send it to me. Show.
Now, Eklund, the Castle Doctrine, or the ability to defend your property, is, I think, older than this country, and it's something that I hope never changes. But I think the legal issue for this couple is going to be this video, because this video shows that that gate is not broken when they already have their guns brandished. That video shows that no one is on their property when they're brandishing their guns. So while I support your ability to defend your home, I don't see their argument really working with this video. What are your thoughts, Eklund?
And you don't have any reasonable expectation of privacy in your curtilage. And they were, you had protesters armed with what? Drums and cell phones. I don't think that exhibited any type of fear that you would have to point rifles and handguns at them. So it's not at night in which they couldn't see. It was during the day. The gate was wide open. They literally told them, hey, I'm on the sidewalk, a-hole. Like, they were just disrespected. They didn't want these type of people in their neighborhood, and they made it known. I mean, all the way to the point in which they were able to present at the Republican National Convention. So I think that all of that all together is going to prove pretty, it's going to be really tough defending them during trial. I wouldn't be shocked if there's like a plea arrangement in this case.
Yeah, and Gene, I'm not sure if we have the photo here, but I think we all know the photo of the woman with her finger on the trigger, pointing it towards the group. For me as a defense, and here it is, for me as a defense attorney, I would have liked if my clients, and you got to take your clients as they come, I would have liked it if they just had it by their side. I think if they just had it by their side, this would have been a great case for them. They would have been able to walk away saying, I didn't brandish it in an angry and threatening manner. I simply had it at the ready. And I think that would be something that everyone could get on board with is, hey, have it at the ready, but the way in which you brandished it, that's when it gets a little bit too far. What do you think, Gene?
Well, here's the thing. I agree with you, but I do want to say this. I'm always thinking as a defense attorney here. I was a prosecutor for a long time. Now I got my defense attorney hat. What helps them is you cannot see, when you got this video filming them, you can't see what they're looking at. You cannot see what they're observing. And that gets to the state of mind. That gets into whether they had a reasonable fear for their life. So I predict they will testify at trial. I don't think they're going to plead guilty, with all due respect. I think they're going to testify because they're going to say, okay, you got this video of me, but let me describe to you, jury, what I saw that's not on the video. And, whether that's going to be the truth or embellishment, he's going to probably say, I saw them coming towards me, getting ready to throw things at me, bottles, tomato cans. The sky's the limit. The sky's the limit.
Gene, I think I wouldn't mind representing this case. I think I can actually beat this case if I had to defend these couples, if that was my duty as a defense attorney. My fear here is whether or not the judge will give the instruction of the Castle Doctrine applying here, because I'm not sure if that doctrine is going to extend past your private property onto the sidewalk. That, for me, I would tell my client, hey, man, it's make or break. If we can get that instruction, we good. We're great. If we don't, that's a hard part.
That's what gets to what Eklund said. If they can't get in the Castle Doctrine instruction, then this will probably end up in a plea, because if the judge doesn't give that, and this would be a motion before trial. Hey, judge, are we going to give this or not? And the judge may say, you know what, I'm going to listen to the testimony before I decide. Then you probably won't have a guilty plea if the judge doesn't rule before the trial.
Yeah, if I'm the defense attorney, I need to get that decision before the trial. Otherwise, Eklund, it's a roll of the dice, right?
Yeah, but another thing, they were both attorneys. So I think that it's different. Like, ignorance is bliss for other people. Like, ignorance of the law is no excuse. However, when you have two like practicing attorneys, I think that would be an issue for the jury as well. Exactly. So I think that it's going to be a pretty hard case to prove, man. It's going to be pretty hard.
Yeah, knowing the law is definitely going to be used against them here, but we're going to take a quick break and come back with more here, the Law and Crime Trial Network.
In the transcript, defendant did not call 911 as he began this chase. He also says, or claims, page 31 to 32, quote, he didn't really know each other. Nonetheless, after he and his co-defendants were arrested, they had contact with each other. And that was testified to in States 22 and 255. It's confirmed in captured call detail 6A, which shows the McMichaels having attempted contact with this defendant. after this murder, and despite his claim that they didn't really know each other. One of the co-defendants actually refers to the defendant as an ally in a recorded jail call. That's on page 66 to 67, which goes again to the obstruction factor I would submit to the court.
All right, Eklund, I'm going to come straight to you, okay? We're finding out, I'm not sure how many people are surprised, that the McMichaels and William Bryan, in their past, through social media and text messages, have used racial or racist terms to describe people of color. And now that's coming back to bite them in the backside because the prosecutor is attempting to use that at trial. What are your thoughts about that and how this could come in and really affect the defendants here?
Oh, it's all relevant, and it should all come in because it all goes to their intent, their motive. It's not a mistake that they were hunting and they were looking for Black people to murder, and we need that. It's all relevant. It's not more prejudicial because it goes to the crime. It actually goes to the theory of the case that they were racially motivated to kill Ahmaud Arbery. So it's all relevant, and I think it should come in.
Yeah. Now, Gene, when I first looked at this, I thought, wait, how are you going to use race as a motive but not charge a hate crime? And I was like, oh, yeah, the state, up until Ahmaud Arbery, didn't have hate crimes on the books. And so because they can't use a hate crime statute now that it's new, they can say that part of the motive, and I'm going back to my law school days of mimic, that you can use extrinsic evidence for motive, intent, mistake or lack thereof, identity or common scheme of plan. Mimic, that's how at least I remember it.
Oh, yeah.
It seems to really work pretty well for their argument as a prosecutor, and I'm trying to see what the defense can argue, but I don't see it there. What do you think?
Yeah, and the other thing I would argue is, even though the statute is relatively new, I would say to the court, Your Honor, it is a new statute, but that statute just reaffirms what we're arguing now before the statute, that their malice aforethought, their motive, their hatred, that is what explains why they did what they did. Motive is not an element of a crime, but it is always relevant. It is always relevant. And that's what I would argue.
And I'm going to give my defense argument in a moment, but before I do so, I want to set myself back a little because I think this is how the prosecutor is going to try to slide in these statements because of what this investigator said was told to him by William Bryan and what William Bryan heard from Travis McMichael, the defendant who's accused of shooting and killing Ahmaud Arbery. Let's take a listen.
Stated on the crime scene that was overheard by one of the defendants and shared with investigators prior to police arriving, correct?
That's correct, yes, sir.
And though this may be an uncomfortable conversation for the benefit of the court and for the record, we're making it clear that this is not your quote, it's not the GBI's quote. This is a quote from a statement of Mr. Bryan as to what he heard Travis McMichael say prior to police arriving, correct?
Very much so, yes, sir.
Understanding that and understanding that it might be a little uncomfortable to talk about the words because it involves a curse word and something else, I need to ask you about that quote. Can you please articulate for the court what Mr. Bryan said he heard Travis McMichael say prior to police arriving and after the fatal shooting?
Yes, Mr. Bryan said that after the shooting took place, before police arrival, while Mr. Arbery was on the ground, that he heard Travis McMichael make the statement, fucking.
So, Eklund, it's going to be tough, but I think the only way the defense attorney can maybe get away around this, and I think it's hard, I know it shouldn't be the case, but I think sometimes when you're making these arguments, it's a little easier when you look a certain way than in other ways. I think you got to, as a defense, split the hair here and say, hey, maybe he doesn't like people of color or he uses this word, but that wasn't his motive here. His motive was specifically, to stop a burglar. This had nothing to do with race. Do you think that's gonna fly here with this evidence so far?
You know what? No, I would actually use a different way. I would definitely use racism as like a mental defect. I would do, you know how like that the kid who rammed into those people when they used affluenza. You know, I would use like a racism argument and say that it was the racism that it was constantly being put out there. They weren't the perpetrators, the racism that made them do it. I think that something along those lines would give them some type of legs. But all that information is coming in. I think that the defense has to be creative at this point because all eyes are looking at this case. All the evidence is pretty concrete that they did it, why they did it. So now you have to come on the defense and try to figure out mitigating circumstances on why they should not be convicted. So, I mean, I would look into stuff like that if I was their defense attorney.
Yeah, Gene Rossi, my personal feelings aside, because obviously I want this to come in. I want them to be for justice and to occur here. But as a defense attorney, I'm thinking, okay, you got to try to get this out. As Eklund said, you got to get creative. But is this something that you think that the defense can get out, or do you think it's coming in? And if it comes in, how damaging do you think this could be for them?
All right, when something like that comes in, if I'm a defense attorney, okay, I'm going to embrace it. And here's how I'd embrace it, because I gotta defend his rights. I'm gonna say, does he hate black people? Yes. Does he want black people killed? Yes. But when he shot Mr. Arbery, he thought that he had committed a burglary and he was a threat to him. And yes, he doesn't like black people, but you got to separate that. And he was focusing on what he thought was no good going on by Mr. Arbery. You have to do that. You have to embrace the elephant in the room. You can't hide away from it.
So, Gene, I actually think that's brilliant. But the one hurdle I think that you're going to have is a little thing called a Batson challenge. Because you need to get the right jury to have that argument. And the only way you get that right jury, Gene, is by getting people of a certain appearance. And I can already see the Batson challenge coming down the pipeline. How are you going to do that, Gene?
Yeah.
Hey, Brian, as they say, minor point.
Just a minor point. Just a minor thing. And I know we're joking about it and we're saying facetiously, but what I'm saying is that argument I think works. And I think any argument could work. I could tell you I'm a 12-foot tall man with gorgeous looks, but that's only going to work for a certain person. I've got to find the right person to feed that argument to. And I think your argument's going to work, Gene. But Eklund, the only way that argument works is I don't think people like you and I can be on that jury for that argument to work. How do you think that's going to play out?
It's jury selection. It is all jury selection. That thing is all jury selection. So I'm curious. I am curious to see what type of jury we get. I am curious.
You know what, Brian? I'm sorry.
Gene.
I apologize, Eklund.
Sorry,
no.
Go ahead.
In my jury questionnaire, I would have that question. How would you feel if you get this? How would you feel if someone said, "I hate black people. I call them the N-word"? What's your reaction to that? That way you get rid of the jurors that would be against your defense. That's one possible way to get that flushed out of the jury.
But that's if the judge lets you try during jury selection. You try the case during jury selection.
See, this is where I think the problem comes with that, Gene. If you're not capable of saying the word, then you are instinctively telling me there's a problem with the word.
I'm trying to protect the Law and Crime Network, okay?
No. And I'm not going to use the word. I don't think anyone's going to use the word. But I think as a defense attorney, when you go up there,
absolutely, yes.
And if the defense attorney themselves is going to, during voir dire, say, "How do you feel about the N-word?" My first thing would be like, bro, if you can't say it, I know how you feel about it. And I think we all know how we feel about it. And I think that it's going to really, I don't know if there's a way around this. I think they might just have to hire some black defense attorneys and maybe just like throw it to the wall and try their best.
They got to go John Grisham with it.
Yeah, I'm already fully employed. I think Eklund's already fully employed. I don't know if one of us can take this on, but I think this is an interesting argument. I'm really curious to see how this affects the jury selection, how this affects the arguments. Anytime terms like this are used, it is a tightrope of an argument for anyone, regardless of your race, your creed. My very first jury trial was a hate crime trial of an African-American man allegedly assaulting 2 Muslim women, and that was a tightrope. I can't imagine when we talk about a white and black issue in this climate, Eklund, Woo!
Now, let me tell you, one of my don't tell anybody, but like one of my things that I love about trying cases is being able to quote. And I love quoting a police report. I love being able to say bad words in court because it's allowed, because it's in quote. So that's me. That's me. And because of my hue, I'm able to say a lot more things than other criminal defense attorneys. But I take full advantage of, quotation marks and, disparaging words. I embrace them, like Jean said. You embrace them and you minimize it during jury selections. You take the sting out during jury selection. You shock everybody. So by the time we're in trial, by the time we're in the second in our third day, we've already kind of calmed some of those waters. So I think it's definitely going to be a really tough hill to fight if you don't have, people of color on the defense.
I am sitting on the edge of my seat to see the complexion and the grouping of this jury because, Jean, is it fair for me to say this, to say that based on who's on that jury, we can see what arguments will or will not be used? I don't know. Just quick answer because we got to go to break. Is it fair for me to say that, yes or no?
100% yes.
All right. Well, with Jean Rossi, your lips to God's ears. If it's 100% yes, then I must be on the right path. We're going to take a quick break and come back with more here, the Law and Crime Trial Network. All right, so we're getting to the end of the show, but let's power through these major cases. First, the Attorney General out of Texas is refusing to resign after members of his own office are asking that he step down. He's describing these as false statements by rogue agents within his own group. Now, Jean Rossi, I want to throw this to you. When I first heard about this, I thought, you know what? I don't really want to get into this. This is probably politics. This is office politics and maybe more. But then I look at the names and their positions. We're talking about Deputy First Assistant Attorney Generals, Deputy Attorney Generals for administration, for the civil litigation, for criminal justice, for legal counsel. This isn't his secretary or a few smaller people making these arguments. These are heavy hitters signing their names to paper to say that in the case of him handling his friend Nate Paul, even though he sent it to an independent investigator, that they're seeing some issues with this. What are your thoughts?
Well, here's the thing. I have actually been involved in a situation in 1997 where high-level supervisors I thought did wrong, witness tampering, violated Brady and Giglio discovery rules, and I reported them to the Office of Professional Responsibility and Justice. It is a huge decision. It is gut-wrenching. It affects you the rest of your life. But I can look in the mirror and say I did the right thing. These people who are signing these letters and calling out Mr. Paxson, they have given to his campaign or are very close to him, and what they see or what they have seen must have been greatly disturbing to them. So it's a huge deal that these high-level people are saying he's doing wrong.
Now, as the Attorney General is describing them, these rogue employees are accusing him of bribery and abuse of power. Eklund, in a time, I mean, it's 2020, I know the elephant is in the room, but we would expect as people and citizens of this country that those that we appoint will check themselves, and those who are working with people in higher powers will say, hey, this guy's not doing the right thing.
Yeah.
Is this not the right move in general, and should we not investigate this to its fullest extent?
I think this is like I love a grand uprising because like Jean said, we do, as attorneys, we take that stuff very seriously. Bar complaints are very serious. Complaints against, your supervisor are very serious because they can be career crushing. So to be able to bring this up, to have this letter, is to say that there was such gross negligence that it was morally repugnant. You understand, he has done such things that can lead him to prison, and they are willing to sign their names off of it. But it also sheds a light on the fact that we need more checks and balances. We have these people in power that feels like they're emboldened to do whatever they want, and they don't have any checks. So we need some more checks and balances.
Exactly. Now, this could be, and Jean, I'm coming to you for this one. This could be career ending if these 7 deputies don't have the right information and they make these kind of false claims. So they've got to be really sure. But also on the other side, there's an equal damage to the Texas Attorney General. It seems like everyone's job is on the line, and the hope is that I mean, someone's telling the truth, someone's lying. So what are the next steps here?
Well, as Eklund pointed out, when they make these allegations, the Magnificent Seven, I'll call them, they have their T's crossed and their I's dotted. They have corroboration. They probably have emails, text messages. They're not just blowing smoke. So they're prepared for the onslaught that this man is probably going to unleash on them. So if I were Mr. Paxton, I would be very leery, because those 7 people probably have memos and documentation to corroborate what they say.
Now, let's switch gears ever so slightly. In the case of the legislator out of the case of Breonna Taylor, where they went and protested, a number of them were arrested and charged with felony rioting charges. Now, the Kentucky state representative, Atisha Scott, and others were arrested, including her daughter, just as she's describing, moments before their curfew, as they were seeking refuge in a church. Now, those felony riot charges have been dropped, but they still have the misdemeanors, and the state representative, as well as the others, are saying we're still going to fight this. Eklund Mercy, your thoughts on these charges? I know we don't have all the facts as yet, we're waiting to collect them, but your thoughts on the felony charges of rioting being dropped because they could not be proven according to the prosecutor, and the misdemeanor charges still maintaining?
Yeah, those are bogus charges. They know they should have dropped all charges, but they're just trying to make a point. They're trying to sully this woman's name. She's done so much for Breonna Taylor and Breonna Taylor's family, but they're just trying to muddy the waters. It is not a good move politically. It's not a good move socially. I think that they were wrong in trying to even it was all wrong, and we all know why they're doing it, and they should stop. All the charges should be dropped. That was faulty. There were no rioting, and no misdemeanor should be applied. She was arrested right before the curfew, so all of this is whack, and I'm over it. I'm sorry. I'm just over it.
Yeah, and I got to apologize. It's Attica Scott. I mispronounced her name. Now, Gene, the felony rioting charges are dropped. The prosecutor is saying that even though they initially argued that this group was causing damage to downtown Louisville, including breaking windows of a restaurant and tossing a flare into a library, Attica Scott is kind of baffled by this because she did so much for this community. But the charges of unlawful assembly and failure to disperse are still there. Your thoughts?
Well, here, number one, anybody who protests and engage in violence, we all agree that's not tolerated. It should be prosecuted. That's number one. But what it seems to have happened here is Ms. Scott's stature as a political figure and in support of Breonna Taylor, that sort of weighed on their decision to charge her. And here's the thing. Peaceful assembly, given a misdemeanor for unlawful assembly and things like that, curfew, those charges are never going anywhere. And if I was a defense attorney, I would fight that tooth and nail. Mm-hmm. I don't know if you get a jury trial for that, but if there was a jury trial, she would be acquitted in a New York minute.
Mm-hmm.
Yep, and then New York minutes, as I can tell you, are very quick. And I think that's how these protesting cases really play out, because Eklund, what jury is going to convict a state representative for protesting? I know the curfew's at 9 o'clock. She's saying she was arrested at 8:58. Is this just defense attorney just going to play hardball until they get to a jury trial and see what happens?
Here's the thing. We're still in Kentucky. So, it all depends on jury. So if we got some racists in there, we got some racists in there. We cannot forget that racism still exists and it still affects Black women, especially it's just analogous for a Black woman to be arrested for trying to support a Black woman that was killed, and being arrested for bogus charges is just how it is. So, yeah, I mean, if we have a racist jury, I could see it happening.
As many cases, I think the prevailing theme I'm seeing in a lot of the subjects we're talking about today, jury selection. Mm-hmm. How you present your information is only half the battle, because who's receiving it and how they're going to receive it is the other half. And it's going to be interesting. Gene Rossi, Eklund Mercy, I want to thank you both for joining us today. A lot of great cases. And the felony charges being dropped, we're going to continue with all of these cases and give you updates as they come up. Don't leave. The Law and Crime Trial Network is still going to be here. Watch the regularly scheduled program. And we'll be back with the Law and Crime Report tomorrow. I won't be here, but I want to wish you guys all the best. Enjoy the rest of your week, and make sure to come back for more expert legal analysis here on the Law and Crime Report. you.